finds his place in the first address made by Dr. Ambedkar before the Constituent Assembly. Likewise, he said that coming from Pandit Jawaharlal Nehru, and who represents the Congress ideology, he said that there is nothing in the objectives resolution which provided for the social and economic equality. And therefore, we find that the directive principles of the Indian Constitution, Part 4 of the Indian Constitution, which provides for directive principles, which is an instrument to achieve social and economic justice, also finds place in the Constituent Assembly, in the Constitution. As all of us know that our Constitution stands on the 4 pillars of justice, liberty, equality and fraternity. The Constituent Assembly put in Herculean labors for drafting the Constitution. 2 of the speeches of Dr. Ambedkar, the first one on 4th of November 1948, wherein he presented a draft Constitution to the Constituent Assembly, and the last one on the 25th of November 1949, wherein he replied the debates on the draft Constitution, are, I think, most important speeches which every student of law should read. And as the Honorable Chief Minister said that he is a student, I am also a student of law, because I always consider that whenever a judge or a lawyer considers that he has now learnt everything, that is the end of a career as a lawyer or as a judge. And therefore, as a student of law, we must reflect upon the Constituent Assembly debates which went on for almost a period of 2 years and more, to understand what is the constitutional philosophy behind our Constitution. As the Honorable Chief Minister said that Dr. Ambedkar always considered, or rather for every citizen, the nation must be first. And Dr. Ambedkar in his first speech on 13th of December said that whenever the destinies of the nation are involved, the destinies of the individuals, the destinies of the ideologies, the destinies of the leaders, the destinies of the political parties are totally irrelevant, and what is most important is the destiny of the nation. And therefore, in the heart of Dr. Ambedkar, it was India as a nation which was the most important. Coming to the main subject, that India and the living Indian Constitution at 75 years, Dr. Ambedkar always considered that a constitution cannot be a static document. It has to be evolving, it has to be organic and a living document. And therefore, the Article 368 provides for the Constitution, for the amendment of the Constitution. There was criticism on Dr. Ambedkar that on one hand he was criticized that the powers to amend the Constitution are too liberal, and on the other hand it was criticized that some of the amendments which require ratification by 2/3 of the states, by half of the states and 2/3 majority of the parliament were too strong, and it was difficult to achieve an amendment in this manner. He said that wherever the amendments were necessary for answering the socio-economic challenges, the Constitution could be amended in a simpler way. But however, wherever a foundation of the Constitution like the independence of judiciary, the federal structure or the other important aspects are concerned, the power to amend the Constitution could not be simple, and therefore it was necessary that some more stringent conditions were required for amending the Constitution. As we see that we gave our Constitution to ourselves on the 26th of November 1949 and which came into effect from 26th of January 1950. The apprehensions as expressed by Dr. Ambedkar came to be true within a short period. In 1950, immediately after the Constitution came, the state of Tamil Nadu, then the state of Madras, had issued a government order providing for reservation for the scheduled caste and scheduled caste. The same came to be challenged before the Madras High Court on the ground that it was contrary, violation of Article 14. The said challenge was upheld by the Madras High Court. It was carried before the Supreme Court in a Constitution bench judgment. And in the celebrated judgment of Champakaran versus the state of Madras,